Well, good morning. Ladies and gentlemen, distinguished guests, esteemed colleagues, and honored speakers, it's with great pleasure that I welcome you to the 24th Annual McCain Conference, this year's topic on ethics and the law of war. This gathering, inspired by the enduring legacy of Senator John McCain, class of 1958, and buried really just steps from where we are right now, stands as a beacon for rigorous discourse and thoughtful reflection on the complex moral and legal landscapes that govern armed conflict. My name is Joe Thomas. I serve as the director of the Stockdale Center for Ethical Leadership. And for those visitors joining us for the first time, and I know we have a few, certainly cadets and midshipmen in the audience, perhaps not as familiar with the Stockdale Center itself. The center was established initially under the name of the Center for the Study of Professional Military Ethics, and that was back in 1998. So it's been a bit, and in that time since 1998, obviously the name changed, and there's a bunch of lines of effort that have been added. But I don't think there's any question about it. The military ethics research component, of which the McCain Conference is a culmination of an annual effort every year, is still the crown jewel of those lines of effort within the center. Now, we find ourselves convening at a pivotal moment in history, a time characterized by rapid technological advancements, evolving geopolitical dynamics, and unprecedented challenges to established norms. The very nature of warfare is changing before our eyes, compelling us to re-examine the ethical frameworks and legal principles that have guided us through past conflicts. Given that backdrop, this conference first examines the law of war, including international humanitarian law's evolution, the instruments, interpretation, efficacy, and relationship to international human rights law, and then explore how and why international humanitarian law might differ from various accounts of ethics of war upon which it is putatively based, and how these differences might affect military operations such as nuclear deterrence, urban warfare, and humanitarian interventions. Now, as we take on such ambitious matters, we're reminded of the timeless questions at the heart of our discussions. Why and how did international humanitarian law develop, and how is it applied by militaries around the world? How do we balance the imperatives of national security with the obligations of international law? In what ways do the law and ethics of war disagree? Do legal constraints on war result in longer and more frequent wars? And there will be more such questions posed over the next 2 days. Now, this conference is an opportunity to learn from what I'm sure will be competing perspectives. The McCain Conference has, for nearly the past quarter century, provided that opportunity in the pursuit of helping develop more effective warfighters and contribute to a more just and ethical conduct of war. Over the next 2 days, we'll engage with thought leaders, practitioners, scholars, and policymakers who bring diverse perspectives and deep expertise to the table. Together, we'll explore the intersection of ethics and law, challenge assumptions, and strive to forge new understandings that can guide our respective institutions forward. Now, I encourage each of you to participate actively, share your insights, and listen with an open mind. It's through such collaborative efforts that we can hope to address the pressing issues of our time and contribute to a future where the principles of justice and humanity are upheld, even in the most trying of circumstances. I also wish to extend our deep gratitude to those who have made this conference possible, particularly the Bloomberg Philanthropies for the generous financial support that makes this conference possible. Of course, Dr. Ed Barrett, the Center's Director of Research, and Professor David Lubon, our distinguished ethics chair, who together begin the planning process for this topic and the content of the conference a year in advance. And of course, Ms. Karen Ornberg, our events director at the Stockdale Center, whose efforts in the planning of the logistics, the travel support, various contracts that make this a smooth and seamless affair. Without her, we wouldn't do this, or so many other things in the Stockdale Center. Now, this conference is held for the 4th consecutive year here at the Jack C. Taylor Conference Center at the United States Naval Institute. The Institute has been a terrific partner in putting together this event, and we hope to maintain this partnership for many years to come. Now, with that, it's my honor and pleasure to turn the podium over to our superintendent. Vice Admiral Yvette Davids is a native of San Antonio, Texas. She is a surface warfare officer and a 1989 graduate of the United States Naval Academy with a Bachelor of Science in Oceanography. She's also a 2002 graduate of the Naval War College with a Master of Arts in National Security and Strategic Studies, and a 2012 graduate of the Industrial College of the Armed Forces with a Master of Science in National Resource Strategy. Admiral David's command tours include the USS Kerch, deploying to the Western Pacific and Arabian Gulf in support of Operation Enduring and Iraqi Freedom. Subsequently, she commanded USS Bunker Hill, serving as Air Defense Commander for the Carl Vinson Carrier Strike Group. And her most recent operational assignment in command was as Commander Nimitz Strike Group or Carrier Strike Group 11. Her flag assignments include Senior Military Advisor to the Assistant Secretary of State for Political Military Affairs with the U.S. Department of State, Chief of Staff, U.S. Southern Command, the Director of the Navy's Learning to Action Board, Drive Team, and Acting Commander, Naval Surface Forces, and Acting Commander, Naval Surface Force, U.S. Pacific Fleet. Admiral Davids assumed duty as the 65th Superintendent of the U.S. Naval Academy on January 11th, 2024. Ladies and gentlemen, Vice Admiral Yvette Davids.
Good morning, everyone. It is beautiful outside, isn't it? Well, I'm so glad you all could join us today. And for our guests that have come in, thank you so much for joining us. And particularly, please enjoy yourself at the United States Naval Academy. It's beautiful here, and we really welcome you all. And I hope you enjoy your time in Annapolis with us. So good morning, distinguished guests, visitors, and members of the Naval Academy team. Thank you, Dr. Thomas, for the kind introduction. And thank you to everyone from our Stockdale Center who has worked tirelessly to put together this absolutely phenomenal conference, with a special thank you again to Dr. Edward Barrett, Ms. Karen Ornberg, and Ms. Sarah White. As Superintendent of the United States Naval Academy, it is my distinct pleasure to welcome you to the 24th Annual McCain Conference. And I'd like to offer a special welcome to our guests from overseas joining us today, Dr. Stephen Neff, Dr. Helen Frau, Dr. Janina Dill, and Dr. David Wetham. We're so pleased you could be here today. And another welcome to the visiting cadets from Army and Air Force and Boston, right there. And the Naval Academy is truly our best when we bring together our dedicated faculty, staff, and student body with academics and partners from around the nation and globe to engage in conversations on the most pressing and multifaceted issues facing society and our armed forces. Here at the Naval Academy, the study of ethics is central to our mission of developing officers of character for our Navy and our Marine Corps. The Vice Admiral James B. Stockdale Center for Ethical Leadership, since its inception, has been leading the charge with respect to our initiatives to further the study of ethics and help forge a deeper understanding of ethical leadership within everyone who works, lives, and studies on the grounds of the United States Naval Academy. The McCain Conference is special because it brings together those in the profession of arms, as well as those who instruct, teach, and develop, and work alongside those in the profession of arms to discuss and debate matters of critical ethical importance. And I would wager there are few issues more relevant to this group and those in our profession than this year's conference topic, Ethics and the Law of War. As officers of the United States military, we bear the responsibility to understand and comply with all applicable laws, and as individuals, we bear the responsibility to understand ethics in that context. The law of war binds not only nations, but individual military members, so awareness of the topics on the agenda for this conference could not hold more weight. And to our midshipmen and the cadets present, when you finally cross the stage on your respective commissioning ceremonies, raise your right hand and retake your oath of office. Make sure you walk across that stage in the full understanding of the moral and ethical responsibility which you are assuming. But as you've chosen to be here today and delve deeper into this topic, I have a feeling you understand that responsibility. So learn as much as you can and make connections with those around you. Those connections can last a career and a lifetime. The McCain Conference serves as a unique venue to bring together the diverse and multidisciplinary perspectives needed to have fruitful and informed debates and discussions on this topic. And I'm sure you'll walk away from this conference having truly examined many of the complexities surrounding the topic of ethics and the law of war. I want to leave you with a quote from President Theodore Roosevelt from his 1910 speech, Citizenship in a Republic. On the topic of war, he said, The question must not be merely, is there to be peace or war? The question must be, is it right to prevail? Are the great laws of righteousness once more to be fulfilled? And the answer must be yes, whatever the cost. Every honorable effort should always be made to avoid war, just as every honorable effort should always be made by the individual in private life to keep out of a brawl, to keep out of trouble, but no self-respecting individual, no self-respecting nation can or ought to submit to wrong. Those words were spoken over 100 years ago, and yet the complexities and the importance of contemplating ethics and war remains just the same today. And I can't wait to hear about it and all the discussions you're going to have today. Thank you, and have a wonderful rest of your conference. Appreciate you all.
Well, thank you, ma'am. Anytime we can kick off a conference with a TR quote, that gets me all in for sure. I appreciate that. Now, I would normally say welcome to our opening keynote on this, but really, Jake and I talked a minute ago. It's welcome back, Captain Jake Romelhardt, who currently serves as the Director of International Operational Law of the U.S. Navy Office of Judge Advocate General, OJAG Code 10. Was here as an instructor in our law section, the Leadership Ethics and Law Department, for a number of years. It seems like only a couple of years ago, but when I reflect on it, it's over 10 years ago now that you've been gone. And he's achieved and accomplished incredible things, as incredible a resume of accomplishment really for somebody in the JAG Corps as I've ever come across. So his prior national security law assignments include legal and oceans policy advisor to the Deputy Chief of Naval Operations for Operations Plan, Strategy, and Warfighting Development at the Pentagon, Chief Counsel for National Security Law at U.S. Africa Command in Stuttgart, Germany, Staff Judge Advocate to Commander U.S. Special Operations Command, Africa, also in Stuttgart, Germany, Staff Judge Advocate to Commander Carrier Strike Group 15, homeported in San Diego, California, Deputy Group Judge Advocate to Commander, Naval Special Warfare Development Group in Virginia Beach, Assistant Staff Judge Advocate for Detainee Operations to the Commander of Multinational Force West in Fallujah in Iraq, and I could go on and on. Between his deployments to Iraq, Afghanistan, and expertise serving not only around the U.S., but around the globe, it is my distinct honor and privilege to welcome back our first keynote, Captain Jake Romelhardt.
All right, good morning. I'm happy to be here for several reasons. One, it's like coming home. Two, it's a nice day. But this morning, I had something happen to me that kind of, I think, shifted how I'm going to present today. I live in Northwest D.C. I have a row house in a very nice part of town and next to all these restaurants. But to be in a very nice part of town next to all these restaurants, it also means I'm constantly dealing with my neighbors who are urban rodents or the rats. So when I went out to my car this morning, I put my garage door up and I tried to put it down, and it wouldn't go down. And so I was like, why is it not going down? Why is it not going down? And then I walked up to the front door and I noticed that, the sensor that goes across that stops, to stop it from going down, the rats had chewed it off. So they had to fall into the ground. So I was here with I live in Northwest DC. I wasn't going to leave my garage door up all day. So I had to figure out a little bit how to be an electrician for a bit. And so that put me slightly behind my planned departure time. And I didn't want to be late. So I was a little worried. And so I thought about it, and then I got here on time, and but it was closer than I would have liked. And so I look back at that situation, could I have planned better? Absolutely, that's almost probably always the case. But I think the thing that allowed me to sort of address this unknown situation is that I had a good understanding of the basics, right? I knew how to get out of DC. I lived there since 2022. I knew where I could come in at the Naval Academy because I had been a professor here before. While this conference center wasn't here, I had recently gone running around here, and I had noticed it because it's so beautiful. So in the course of my daily life, I figured out I knew where to go. And so in that unknown situation, I had the tools necessary to analyze it and do it in a way that I was able to meet my goal. And I think that's kind of what I hope to give to you guys today as you go into this conference, because there's lots of things I could tell you, and I've been a consumer of these presentations for almost my entire professional life. And now that I am the producer of these presentations, I want to make the most of our time together. And if I had my druthers, I would just take questions all day long, because I think that's what I really like to do, and I like to hear what you're thinking about. But I think what I'm going to do, so I decided to do this morning, is I'm going to talk about principles that everybody should know. So I'm going to give you the basics, because we live. I saw, it was like a TikTok or a meme the other day where the guy was I would just like to live in precedented times for a while. I've had enough of the unprecedented times. But that's not going to happen anytime soon. So I think there's a lot of important conversations that are going to come up, and I think we need to be able to speak the same language and offer our expertise. So I'm going to talk about certain principles that everybody needs to know, ones that I hope will serve you over the next 2 days, and then I'm going to talk about some examples of how we have adjusted to recent challenges in the past. And then the last two ones, I have delegated signature authority from the Secretary of the Navy. I'm the person who can sign all weapons reviews for the Department of the Navy. So I can, as you can imagine, the weapons reviews that come across my desk are not bullets. They all sort of involve, and I'll talk to you about it when I get there. They all involve some type of machine learning algorithmic inputs. There are two words that I hate, and so I hate the term lawfare, and I'll explain that when I get there. And then I hate the term AI. I think AI is a useless term. I mean, you can use it when you talk about at the dinner table or with friends, but when you come to a policy discussion, I don't allow the people to use AI. And then I was in Copenhagen a few weeks ago at an AI conference, because there's a lot of commercial shipping in Copenhagen, and they're looking to do commercial shipping without manned crews on board. And I just basically told this whole room full of academics who have committed their life to AI already that we're not allowed to use the word AI, so that went over really well. But the reason that I think that, and I think it's kind of a theme of what I'm going to talk about today, is that I think AI is a sexy topic now. Like, if you are an academic who wants to get published, I think you want to put AI in the title. But what it also is like, it's not precise. Like, what is AI? It doesn't have a definition. And what it does is it lowers the barrier to the entry of these important conversations, right? And the costs. And so people are coming in with all this stray voltage, not prepared to talk. So I prefer to talk about systems, right? So is it AI, or is it a robotic system with algorithmic input that operates at sea? Because once you know those, you can talk about the issues there. Because if you throw out AI or terms like black box, people get scared, or people are acting on assumptions that they haven't fleshed out, and the conversations just don't go anywhere. So with that, I will talk about the basics of international law. And I think, so to start off at the beginning, you can see that it's like, what does LOAC, or Law of Armed Conflict, International Humanitarian Law, and people often ask me the difference. I think there's an academic difference. I don't think my advice would have ever changed based on the use of those three terms. Next week, I'm going to be at Harvard Law School talking to a bunch of academics, so I will use international humanitarian law. I tend to not like the law of war, because us in the naval service, like the law of armed conflict and international law applies to us all the time, even in peacetime, right? There are certain rules that govern our, the navigational regimes at sea that aren't contingent upon a conflict. But I try to know my audience, right? And I think, the reason I have this slide is when I was at U.S. Africa Command, my boss was a 4-star Army infantry officer, and all of the services have they have their strengths, and one of the Army strengths is PowerPoint. Like they're really good at it. They have like swoops and stuff. But I was going to we had an offsite, and I was going to go to my part of the offsite and to present, and I had written a page, and the XO, or the Admiral Townsend's aide, comes up to me and says, what they call it, the XO in the Army, he comes up and says, all right, where are your PowerPoint slides? I'm like, oh, I don't use PowerPoint. He's like, what? I was like, I don't use PowerPoint. And he's like, huh? Right? And so I was made to have a PowerPoint slide, but this was my protest. This is the format I came up in protest. No swoops, black and white. But, and the thing is, like, as a lawyer, you realize, like, if I have the best legal advice and no one listens to me, or I haven't earned the credibility through other intangibles to listen to my advice, it's worthless, right? So I'd rather have give mediocre advice that my client listens to, or the person I'm advising listens to, than give perfect advice that doesn't go anywhere. But I think this is good based on what you're going to be talking about. So the law of armed conflict sets a floor. The law of war sets a floor. It is not meant to be a tactical directive. It is not meant to, like, sort of dictate all of the behavior on the battlefield. Think about it, like when I was a kid, like I played the cello, and I would sit at home and practice, and I would play like ode to joy, right? So does it sound like ode to joy? Yes. Is that how ode to joy is meant to be heard? No. It's meant to be heard in an orchestra with the brass and the woodwinds. So as a lawyer, sometimes I get asked to do things that are not legal, and I can do it, and it will sound somewhat like it's supposed to be, but it would be much better if the person who's the expert is involved in the conversation. That's how you should think about the law of armed conflict and the law of war. And I think that's why I think this conference is really great. So I'm going to go through all these, and then we'll talk about it. The sources of international law and the enforcement mechanisms. It's important. I think the way that I talk about this distinction is we compare it to domestic law. So here, like if you have a speed limit, when I was at the Naval Academy, I was also a U.S. attorney, so we would prosecute things on this bridge that happened right there. And think about a speed limit. Like who sets the speed limit in the United States or in domestic law? It's a legislature, right? So you have these elected representatives, and they sit down and they say, this is in the public's interest. We want the speed limit to be here. We're going to post a sign. We're going to put people on notice, right? But who does that in international law, right? Because we operate on this nation-state system. There is no sort of super governmental legislature that sort of goes out and promulgates these laws of war or the laws of armed conflict. So where do we get international law from? Well, the sources are quite different. I think it's important to understand these sources to understand some of the issues that we have and some of the ways that we can shape international law to our interest without being unethical or gaming the law, because you have to understand how the law of armed conflict developed, right? So most of this, the International Legal Project, as we call it, it happened after. It started in the late 1800s, but I think the system as we know it really came to be after World War II, right? And what it was is hey, we recognize now that we had this view where you have people, citizens who report to their government, and at the time they thought the government was the one that held the power. I think since then you can argue, especially in European countries, that they have come to the understanding that it's not the government who holds the power, it's the people. But we saw that when a government has unchecked power or feels like they can act with impunity, they can do some pretty horrific things. And so they get together and they start to form these international norms, and then the modern view of international law comes about. And so what are the sources of international law? I think there is something like a speed limit, right, where a government who, through whatever theory of legitimacy, gets together and says this is the standard that we're going to abide by, and those are treaties, right? And but treaties are a little bit more complicated because treaties have an international flavor, but they also have a domestic one. And so every country is going to have a system or a mechanism for making a treaty binding on their country. And so what is think about what that system is in the United States to make a treaty binding on the United States. It involves two parts of our government, right? It involves the executive and it involves the legislature. The executive signs and then the Senate ratifies. That is pretty straightforward, and it's much like the speed limit. And if that were the only place that international law came from, I think things would be relatively straightforward. However, there's another source of international law that really doesn't quite have that same analog in domestic law, and that's what's called customary international law. So aside from treaty law, customary international law is this principle that you need two things. You need state practice. So when a bunch of states start practicing something, and then the real issue is with the second prong, and they need to be practicing it based on the opinion that it is legally required, or it's called opinio juris. If you have those two things, then it becomes customary international law and becomes binding on all nations. Now, this is very different than domestic law, and as you can see already, probably it leads to questions of we have this law that is binding on all nations, but where is it written down and how do we enforce it, right? And why do we have this little quirk? Well, I think there are a lot of theories of why we have this little quirk. The way that I see it is, or I've conceptualized it, is that after World War II, they tried sort of Nazi leadership in Nuremberg. They came together, and they wanted to charge them for the crime of genocide, right? So the systemic steps taken to destroy a population in whole or in part. And so they had lawyers, and we gave the Nazis lawyers, and they went up and they said, you are guilty of the crime of genocide. And under most Western legal traditions, there's this principle of legality. The principle of legality is that we can't hold you criminally liable for something that wasn't said to be a crime beforehand. And so the very good lawyers on behalf of the Nazis said, you can't try us for genocide, right? You can't try us for genocide because there is no law, it's not written down anywhere that you can't commit genocide, which I think is a good legal argument. It doesn't make it's not very intuitively satisfying, right? And so they had to figure out a way that to say that these people are on notice that genocide is a crime, even though it wasn't written down anywhere. And I think that's where this notion of customary international law came out. And it said, listen, there are certain things that are just so obvious because of practice and opinion that it doesn't need to be written down for us to hold you accountable for it. So that's sort of what people are trying to deal with, or that's what the International Legal Project is trying to account for when it talks about customary international law. And so it has a goal, it has a purpose. It is also extremely difficult to work with. And that, for one of the reasons it's also difficult to work with is because of the enforcement mechanisms. But what are some examples of international law? We're treaty law, and what are the examples of customary international law? Well, actually, we have one that's both, right? So the United Nations Convention on the Law of the Sea, UNCLOS, is actually an example of both. So it's a convention, so you look at it, so it was a convention written in the 1980s sort of to govern the maritime zones and our rights at sea. It governs a lot of other things like mining and coastal shelf claims, but for me as a Navy lawyer, that's the important part. So when I was at a strike group or I worked at fleets, I would fly out to ships and I would go and talk to the war room and to everybody about these are your maritime zones that are established in UNCLOS. This is what UNCLOS says that you can do there, and this is what they say you can't do there. And this is something that is very important to the Navy, especially because we want to maintain freedom of operation at sea. And UNCLOS also covers the air. So if I'm going out, you would think if I am like Lieutenant Romelhardt is flying to these ships and instructing people on UNCLOS, which is a treaty, you would think, well, then the United States is a party to it, right? Is the United States a party to UNCLOS? You probably run it, right? No, it's not. Like it was written in the 80s, and then President Reagan did not sign it because he had some issues with deep seabed mining provisions in it that have since been rectified, and President Clinton signed it in the 1990s. But even though President Clinton signed it, it has still not been ratified by the Senate. So the United States has not gone through its domestic processes to become a party to UNCLOS. But then why is Lieutenant Romelhardt flying out to these ships and telling all these SWOs that this is the thing that we stand on? And that's because we have an executive policy that says we are not party to UNCLOS, but at least the provisions in UNCLOS that set up the regimes that we were worried about, it is our position that those reflect customary international law. And so even though we're not a party to it, it is still binding. But you see that's kind of it sets up an interesting debate, right? Because I think every new administration, and I have been involved in these discussions recently with the new administration, is if this is how we look at it, like why should the Senate even bother with this, right? And I think that the reason that the arguments for and against are probably because of the nature of customary international law. So if every other country, and it's almost every other country, is a party to UNCLOS, and things are changing, right? I think you see that things in the Red Sea and the Suez Canal are making the Arctic a lot more important, especially the route from Rotterdam to Shanghai. In those places where the law is not well defined, UNCLOS has provisions in it to deal with that. Like if they have bodies and tribunals and people who would get together and discuss these new issues, and then they come to a conclusion, right? So if all the countries in the world are party, except for the United States, are party to this document that sets up these provisions where people come to these conclusions of what the law requires, and then so what's the danger then if we don't participate in those discussions, right? It makes a very strong argument that anything they do is almost customary international law, like from the get-go, and that means that we don't have a seat at the table, and that's the argument I think people put forth for like why we should ratify UNCLOS. I think there's some arguments against it. Some people take different views of the International Legal Project and sovereignty in general. But you also see it gets very political very quickly, right? And it has very drastic implications for what we can, what happens and what we can do. So that's the sources, enforcement mechanisms, right? Back to the speeding ticket example. Like if you're driving across the bridge and you're going too fast, what's going to happen? There's probably a police officer has a means to gauge your speed. gauge your speed. She'll pull you over, and she'll say, "Do you know why I pulled you over?" And you'll say, "I wasn't. No, I don't, officer." And you know you were speeding. But and so she writes it for you, and then she gives you a ticket and a citation, right? And so in that citation is going to be a representation that an agent of the government has observed you violate the law. Now, do you have to just have to sit down and take it? No. We have mechanisms to say, well, if you want to trust that agent of the government's version of the facts, then you go through this sort of fact-finding process, and and that's our criminal trial system. So, I mean, it's pretty straightforward of who is alleging the violation, where you go to say to disagree with that alleging the violation, and then if you are found to be guilty, the crimes or the punishments are laid out, and the person who decides what punishment are is pretty clear, right? None of those things exist in international law, right? Are there tribunals for violation of international law? I guess yes, for the most part. In some cases, it's very clear, like in conflicts where there's really a need for a tribunal. The UN can set up one for like Rwanda, the former Yugoslavia. But really, at the end of the day, there isn't, right? There is no place to go and plead your case before a judge who has the ultimate decision-making authority to determine whether you violate the law. Actually, there's a lot of disagreement often about what the law actually is, right? So what are the enforcement mechanisms that we see in international law? It's soft power, right? So there's diplomacy, and you can get sanctions, and you can seek a Security Council resolution that you're violating certain rules of international law. But at the end of the day, it's diplomacy and soft power, because it's the country that's going to an ally, the politician of an ally, and saying, "Come work with me on this military operation," and it's that politician saying, if I join up my country in this operation, is it okay with me, what I feel inside, which is internally motivated, or is it okay with the people who vote for me and what they think, right? And if those people can go and say that I am involving our country in these conflicts or whatever this operation is on a theory of legitimacy, and that international law supports this, that is something that is very powerful, and that's something that's more likely to make a coalition operation rather than a state operation, right? And I think I'll go back to the purpose of the law of war, because I missed something and I apologize. Remember this, your takeaway from this is that ROE rhymes with 3. So ROE rhymes with 3 is that, it's to say, like, a lot of people think the lawyers own the ROE, and it's not. The 3, the operators do, the operations, the G3, the N3, the S3. And it's really important to understand that, because what are the sources of the rules of engagement? There is a strong legal component to the rules of engagement. That is absolutely clear. But that is not what drives the rules of engagement, right? There are operational requirements, and then there are policy requirements. And also, I think sources of the law of war, when you have customary international law and you have treaties, do I go out and sort of cite the Geneva Conventions when I'm advising troops working in Africa? I don't, right? So how does the Geneva Convention get translated to the tactical units, to the groups on the ground? It gets processed and chewed out through orders, right? You have the National Security Council that will turn to the Secretary of Defense. The Chairman of Joint Chiefs will issue something on behalf of the Secretary of Defense to Commander U.S. Africa Command. Commander U.S. Africa Command will issue guidance to the Naval Component Commander, and it goes down. So nowhere will you ever see the Geneva Conventions require this. What you will see are a bunch of orders and directives that cite to the Geneva Conventions, but commanders have given their guidance on top of it, right? So when I was in Afghanistan, I would advise on kinetic strikes, drone strikes, and there was a tactical directive, and the tactical directive talked a lot about, in Afghanistan we would do a lot of operations at night, and it was really important to sort of empower the Afghan governmental institutions that we're setting up there, and also to get sort of community buy-in. So the commander of U.S. forces, or maybe it was NATO forces in Afghanistan, issued a tactical directive, and the tactical directive said, when you are catching fire from a location, you can always respond in self-defense. But I, as your commander, right, I want you to consider fire and maneuver and withdrawal before you level a house, right? Now, does the law of war require a commander on the ground to consider fire, maneuver, and withdrawal before leveling a house that is under fire from? No, right? That is not a legal requirement. So why do you think this was a tactical directive? Because what happens when you level a house, right? It doesn't help you win over the community, right? So I think that was the commander saying, it wasn't the law saying you can't do this under these circumstances. It was the commander saying, I need you to consider this because this one operation or this one decision and your realm of influence is going to affect my ability to meet my objectives at this level, right? So that's the sources of law, and I think that's why it's important for people in this room to have these tools to be able to have those conversations. Because I, as a lawyer, I have a lot of experience in certain areas, but I don't know. I wasn't a 4-star Marine general, right? I don't know that I prefer fire maneuver withdrawal over leveling a house. I would just tell you that they're both permissible, right? And that's important because I think this is where we get to substance and procedure. So substance and procedure, a lot of, as you will probably learn today and tomorrow, a lot of law of war determinations are discretionary. And what it means is it says it invests someone with power, and that person gets to make a decision, right? And that decision, discretionary decisions typically are not subject to review, right? And so how do you keep someone in check when they're discretionary, when something is left to their discretion? Well, the way you do it is through procedures, right? And it's important to know what substance is and what is procedure and where it happens. So when I was a professor here, I was talking to the detailer about my next orders, and they said, hey, there's this training command down in Virginia Beach that are screening people. Do you want to go and screen? I'm like, no, I don't want to live in Hampton Roads, and I don't want to go to a training command. And the superintendent's lawyer at the time was a Navy SEAL who had become a lawyer, and he walks to my house in Luce Hall, and he sits me down and he closes the door, and he's like, I think you should just go, why don't you go down to Naval Special Warfare Development Group and check it out? I think you'll see that's the type of training command that you like. And I liked him, and I didn't want to go, but I went down there, and I drove down the Eastern Shore, and that is like a conversation that changed my life. I would be a completely different person. I probably wouldn't be in the Navy anymore if I didn't like this guy, right? But one of the things that I did when I got there, so I got the job because I was the only one who made it through screening. People ask, like, how'd you get the job? I'm like, well, I didn't drown during the swim. But one of the things they would do is they would farm me out to special operations task forces around the world. And one of my first jobs, I would sit in a joint operations center and advise on drone strikes, right, or connect strikes. And at one time, so the way it happened at the time, the president, at the time President Obama, would issue targeting criteria, and then that would get disseminated down to the level where I was advising in 06. So we would sit in this jock, and the commander's sitting here, and this is how you can tell how special operations value their lawyers, right? The commander's sitting here looking at the screen. This is his operations officer, the J3. This is the intel officer, and then I was right there. So in the front row, those were the 4 people. Those are the 4 people in every meeting. But as a lawyer, like, why was I in those meetings? Because as a lawyer, I almost never, ever make a decision, right? What I do is point out the things that you should consider in a decision, but like I almost never have a decision, and I'm very cognizant of that, and I always know substance and procedure because I always want to keep my role. Like, and always, like, if I was in a meeting with General Townsend, I would say there is no legal objection, and if I've earned my spot on a staff, they might care what I think as a policy-wise, and I would say, well, you might want to consider this as a policy rationale, but I'm not the foreign policy advisor, right? So I think, so I was there, and I would sit, and then the person who made the decision in those situations was the 06, and those were delegated down from the 3-star, and that came from whatever area of operations at the time. This particular story I'm talking about was in Yemen, so it would have been Commander U.S. CENTCOM. And so the targeting criteria was that we had to know that we had a targeted individual. We'll call him like Objective Carthage, right? So yeah, like our targeting naming conventions, you name the high-value individual an objective, and usually it had something to do with, like, if it were like cities in Ohio, it was this type of target, and if it was like cities in Florida, it was other types of targets. This one I'm talking about, I won't say the objective name, but it was kind of funny because it was like cities in Ohio, and then it was like Cincinnati, Cleveland, and then it got to Troy, but no one got the memo that it was Ohio. They thought it was Troy of ancient Greece, so then it changed to like Athens and Sparta. So we'll say it was Objective Carthage, and so we knew that the guy was there, and we were watching on full motion video at night, and so we had a pretty good idea the guy was there because of intelligence, right? We knew that we had human intelligence putting him there, and then we had signals intelligence that the cell phone that he typically uses is also there at that time. So it was late at night, and it was a part of Yemen that Al Qaeda and the Arab Peninsula controlled, and there was a fire, and there were people around the fire. And at the time, what we had to do is we had to figure out that the guy was there, and then we had to figure out that everyone else around him was members of Al Qaeda in the Arab Peninsula. And so, and with reasonable certainty. So we're watching, and then the captain at the time was like, all right, and he talks out loud. He's like, okay, the selector's there. I think based on human intelligence, signals intelligence, this is Objective Carthage. Based on the location, the known control of the area, I am assessing all the adult males in the area also to be Al Qaeda in the Arab Peninsula. That's great, all right? So we're watching and we're watching and watching. We're lining up a targeting solution. And then over in the corner, there's some trees, and you see two figures walk in, and they sit down. And as they're lining up the targeting solution, they're chatting, and then he was about to give the command to fire the Hellfires to blow up the people sitting around the fire. And I had said, well, I stood up and said, hey, wait a minute, like, I just really need you right now. There are two people who came. I need you to say out loud in this room, right, that why you think those two people are Al-Qaeda in the Arab Peninsula. And he talked, and he talked, and he talked, and he went through the reasoning again. And he fired. And so the campsite blew up, and it killed most of the people around. It didn't kill the person we were aiming for. And then the next day, it came out that there was an airstrike in Yemen, and it killed a 14-year-old American boy. So it was the son of Anwar al-Awlaki, and Anwar al-Awlaki was an American that had just been killed in Yemen before. And that was no one's desired outcome, right? And I think, but what happened, was there an investigation? There was absolutely an investigation, right? And it came down, and what happened to the commander that made the decision? He became an admiral, right? And the reason he became an admiral is because it was a good shoot, and it's not the result you were looking for. But the reason that he became an admiral is because the procedures were good, right? The discretion was vested in him to make the decision, and when his decision turned out to have some effects that we did not anticipate, we were able to produce the procedure that said, well, this is what we were able to do. So that's the importance of substance and procedure, and that's the importance of understanding how these things operate, because it can get, like, if you're ever in one of those rooms where people are making decisions to launch a kinetic strike, I will tell you that all of the things that are primal in us come out, right? There's groupthink, there's the desire, and if you think the reason that we have decided that we should take these lives is because they're a threat to our people, right? Because that's the legal justification that we're working on. There are a lot of very primal human things at play. So you need to understand what those things are, and you need to understand the need to counteract those things. Because I think, I read the investigation from the Kabul strike, the one after we just left Afghanistan, and there are lots of mistakes in that case. And I think, I wasn't in there, I won't say, but I will say that the leadership in those rooms is extremely important. Leadership to allow people to speak up is also very important. And I think, but that takes the person who's invested with the substance, the person who gets to make those decisions. It takes him or her saying, "This is important to me when making my decision. I want you to dissent. I want you to tell me where I'm wrong. I don't want you to tell me that I'm not thinking about." And I think knowing substance and procedure allows you to have those conversations. So, okay, all right. So I love questions. Does anyone have any questions right now? And then I'll talk about those are the kind of principles. So what's your takeaway? Purposes of the law of war? It's just one thing, right? It's not everything. So lawyers should work with operators and policymakers to figure out what is the cohesive policy that fits our interests, right? And so a lot of things that are legally required or are legally permissible aren't good from an operational level or aren't good from a policy level. Sources of the law of war, they're different, right? And so they're very hard. They're hard to nail down. Enforcement mechanisms, not a lot, right? And substance and procedure, important. Okay, so right now I'm going to talk about the past, present, and future, because these are ways that I think that can illustrate what I'm talking about here, right? There's a word in the law for people who just blindly apply a rule and not thinking about its context and its applicability, and that word is malpractice, right? So you need to figure out where you're operating and what rules you were having fit your needs now. And so let's talk about the war on terror. The war on terror is what we call a non-international armed conflict. And for people who are my age, or at my experience, this is the only thing I ever knew until recently, which is weird because it's not what law of armed conflict or the law of war was designed for. The law of armed conflict or the law of war was designed for conflict between states. But in 2011, we saw a recurring theme where we are fighting against or have conflicts against these groups that aren't tied to a state, but they're operating in a state, right? So there's no government per se, but they have great leadership structures, but they don't own any territory in a political sense. So it raises some issues, right? Because we are applying it to these circumstances that's not meant for, and we applied a lot of things by analogy, but certain things came up. And one of the major things that came up was law enforcement versus law of war. And what do I mean by that? This is always going to be a tension. You see it in Star Wars. You see it in the War on Terror. It's this fight between the rights of the citizenry and the ability of a government to take steps that it feels to protect itself, right? And you saw this a lot after September the 11th. And I think this comes up also, like when I go out and give ROE briefs, a lot of people have this conception that the rules of engagement are too restrictive. And I will push back on that, because when I hear too restrictive, what do I hear? I hear, in the default, right, in the daily life, you can go around killing anybody that you want. And the rules of engagement are restrictive because usually you can kill anybody you want, but the rules of engagement tell me I can't kill this person, right? That's how I read restrictive. I'm willing to argument. So, are the rules of engagement, is that how it works? Do I get to kill everyone every day, and then just so happens when the rules of engagement say I can't kill somebody? That's not how it works at all, right? I mean, can you kill someone in your daily life? Typically not, right? Under our law enforcement, and then in order for the government to kill somebody under a law enforcement paradigm or a law enforcement framework, it has to be a certain kind of offense. We have to give someone a certain kind of defense. We have to give them attorneys. We have to give them appeals, right? That's how the government can usually put somebody to death, right? Is that how? But was all that stuff happening when I was in the room advising the government on how to take those people's lives and around the fire? Absolutely not, right? So there at some point, this desire to protect the person and give them all this due process and appeal and access to the evidence against them turns into this. It's people sitting around in a jock with authorization from the president to shoot a campfire, right? And you can see they're two very different scenarios. And you can see why one might be appealing to people all the time, and one citizens wouldn't like all the time. And you see this in all sorts of ways, right? Arrest versus detention, right? So how do we usually deny someone's liberty in the United States under the federal Constitution and the 14th Amendment, right? Due process, right? And due process changes based on the right at stake. But generally, due process, for us, the gold standard is the criminal trial, right? You have a right to confront the evidence against you. You have a right to an attorney. You have a right to an appeal. And then, you go through that, and then you get deprived of your liberty, right? But we have detainees at Guantanamo Bay that have been detained for how long, right? Now it was 24 years, right? And have those people ever seen the evidence against them? Not all of it, right? Have those detainees ever confronted their accusers? No, they haven't. Have they ever been before a judge in our Article 3 sense? They haven't, right? So how is that able to happen? And I think it's this distinction, right? And a lot of times these are political calculations, and I think you see this a lot in the intelligence collection sphere, right? And I think when I was getting my LLM at Harvard, two things were very in vogue at the time. One was to talk about drone strikes, which was weird for me because I went to a course that I was taking, and they brought in these guests to brief a legal advisor to brief an operation that I was a legal advisor for. I couldn't tell them I was a legal advisor for it, but it was nice for them to tell me what I was thinking at the time, because they thought the lawyers had this ingenious legal scheme, and I just want to go to dinner. But it's just a different perspective. You see this all the time, and I pulled out this quote because I think it's interesting to know. At the time, people were very upset, and I don't know if you know much about the Snowden revelations, but Snowden leaked some documents that talked about these NSA programs that allowed for a mass collection of intelligence under things that were authorized for national security. And here's the thing that if you guys are going to work in intelligence, here's the thing you need to know about the intelligence community is that. And there's no indictment on them. The intelligence community, as we know, it was more or less established in the late 40s after World War II. And since that time, it seems to work well, and then there is either a scandal or a shortcoming that takes a hard look at it, right? So in the 1970s, if you're ever going to be in intelligence, I would say pull the Church Committee reports. The Church Committee was a Senate committee set up to look into several incidences where intelligence practices were suspect. One of them was when the FBI was monitoring Martin Luther King. One of them is when the CIA set up a brothel in San Francisco, and they would bring in unsuspecting people, and there was a two-way mirror, and the women playing prostitutes would give them LSD, and then they would watch the person. So they were medically experimenting on Americans without consent, and there's a bunch of other things. And then, so there's the Church Committee reports, they have all these recommendations, and then things hum along. There were some scandals in the 80s, but then that next big punctuation is September 11th, right? And September 11th comes along, and there's all this failure to synthesize intelligence, so there's an investigation, right? And in all these things, certain themes come out, right? The Church Committee is like, hey, these things happen because of excess secrecy, lack of transparency, and so an inability to show things to people to get oversight, right? And they, all right, we'll fix those things. And then It gets to September the 11th, and the September 11th committee comes out, and they say, you know what, this inability to synthesize information is because lack of transparency. So there are problems inherent in our system, and I'm not saying this is a bad system. I think every system is going to have it that you need to recognize. And this is what, so you have the church committee and you have Snowden. This is what the people from the church committee wrote about Snowden. It's like, we have seen a consistent pattern in which programs initiated with limited goals, such as preventing criminal violence or identifying foreign spies, became as vacuum cleaners, sweeping in information about lawful activities of Americans. The tendency of intelligence agencies to expand beyond their initial scope, intelligence programs to expand beyond their initial scope is a theme which runs through every aspect of our investigatory findings. So these are people from 1970 saying, like, these are issues that we noticed in 1970, talking to people in 2013 saying the same issues that we identified in the 70s. And the reason I bring this up is it's really important to understand this distinction, because there are times where we need to deviate from the standard, where we should not provide people the gold standard of a criminal trial, because the ends are different, right? Like, if those people in Guantanamo is the reason to rehabilitate, or no, the reason they're there is because to prevent the threat that they pose to us, right? So I mean, you can query what threat they pose to us now. But what happens is like those procedures are easy, right? You don't have to give someone a lawyer. You don't have to go through all these processes. So it seems to be like people like that. I mean, people who have to get something done like those procedures. And then, like, no one likes to have their decision subject to review. It's just not like someone who's been investigated many times. It's not a fun process, right? And so people like to have their decision to be immune from review. And usually what will happen is you will make these decisions. So these decisions about Snowden and September 11th were made after the country was reeling from an attack on our soil, right? But what happens is it's easy to establish these programs. It's really hard to get rid of them if you don't put in like a sunset provision or a termination date. But that's why I think, if you ask me why this keeps happening, I think what happens is the political process authorizes a program where people think it's okay based on the risk they assess at the time. But like as you move farther and farther away from the attack on the Twin Towers in the Pentagon in 2001, is saying like these things justify then when you were scared, and so then you start these programs and they operate outside of public view because that's the nature of intelligence, right? The public like perception changes. Their perception of a threat changes, so their perception of what is permissible changes, but there's no one talking to each other, right? So this intelligence program goes along at the 2001 threat assessment. This is changing, and then no one notices until something happens, right? And they're like, whoa, like, how did you get so far off course? And so I think that's why I bring that up, because this is something that was really shown in the War on Terror. I don't know, and it's always interesting. I think you guys should be thinking this week, like, what we're victims of our own experience, like, what are our biases? So I can see this very clearly in the counterterrorism context. I don't know what it is in the current context. I mean, I think it's worth thinking about, because I know that the tension always exists, and the fact that I can't identify it doesn't mean it's not there, right? And then targeted killing, that's the other thing, is that another thing in the War on Terror, and I just talked about that with the Anwar Laki's son, but it just changed the way that we do targeting, right? And I think the community and the country was very spooked out by it, and I don't think they understood the decision-making process. I think they thought the second lieutenant who's flying the remote piloted aircraft is the one making the targeting decisions, and that's what they told me at Harvard. They like joystick warfare, video game warfare, and people were very good. I snapped at somebody once, and I didn't snap. I was very convincing, and of course I was like, hey, like, I know that you don't mean offense to it, but like somebody. It's hard for me not to take it personally that you don't think that I understand the gravity of the decisions that I'm involved with when I'm in the decisions, right? And I also say, like, and for you to think that, like, it doesn't affect you, like, when the best thing that can happen to you today is that you help kill somebody, like, even though it's on a screen, it still affects you, right? And like, if it doesn't, I'd be worried. But so I'm like, just watch your rhetoric, man. So, but I was Jake. I was Jake. I wasn't like in my uniform at the time, but it's all those things I was talking to you about. Like, it changes the way that we target. It changes the way we make engagement decisions. So it needs to change the way we think about things. I think it's good in some ways, and I think it's bad in some ways, right? And like one of the things I was talking about, like the human process, is we had I was advising on a kinetic strike. This was in Yemen, also a different part of Yemen. And the guy we were talking, he was actually going to the bathroom in an outhouse. They asked me if an outhouse is protected under the laws of war. I said no. So they shut the outhouse, and like the outhouse. it falls down around him, and so he survived. The blast radius of a hellfire is very small, so he pulls up his pants, but he's limping and he falls down. And so we're watching, and then everybody's standing up, and a white van pulls up, and the J2 was like, all right, there's a white van, that's a terrorist van. And I was like, or, hear me out, what else is white that we put injured people inside of? Right? Could it be an ambulance? And they didn't know, so we didn't shoot. But but that's the thing that you just kind of have to take people out of the moment for a second. And I think those are lessons that we've learned a lot in targeted killing. And then what else did we learn from non-international armed conflict? Non-international armed conflict is us fighting groups in states that aren't the government. So it leads to very novel questions. And one of the questions, one is riot control agents. So when I was in Afghanistan, there was foreign workers I was at Bagram Airfield, saw young sailors loading Korans into the burn pit, right? And it was not handled in the right way. And so they took pictures, and those pictures got out, and there were riots all over Afghanistan because the sailors did nothing wrong. It was a leadership failure. But burning the Korans, riots everywhere. And in Afghanistan at the time, different bases were run by different coalition partners. So the riots at Bagram, they used riot control agents. Riot control agents is an interesting thing under international law because there's a thing called the the Convention on Chemical Weapons. And in the Convention on Chemical Weapons, it talks specifically to riot control agents because there is no way, treaties and conventions, you always have to be worried about definitions. There is no way to define riot control agents that allows for the use of riot control agents that doesn't allow for the use of chemical weapons, right? And essentially they're a chemical that you use for a purpose that has an effect on the body. So the prohibition against using riot control agents in an international armed conflict is pretty clear. The language in the convention is you can't use riot control agents as a methods and mean of warfare. And so what happens is that's a good standard, but it's not a definite standard. So it goes to the individual countries to interpret how that works under domestic on their domestic policy. And so the United States, we said, well, if you're guarding a base that's like a law enforcement operation, it's not a method of warfare. So people working the perimeter at the base at Bagram are allowed to use riot control agents. It doesn't violate the convention. So they did that there. And there was a Dutch base. They did that at the German base. They interpreted it differently, and they didn't use riot control agents. And 2 of their guards guarding the base got killed. Right. So also an investigation. And I went out to talk to the Germans, and I was like, "Why didn't you use riot control agents?" And they said. He said, we understand your interpretation of how you can use riot control agents. You have to understand for us that it's not a good optic for German soldiers to be using riot control agents that could be classified as chemical weapons in anything. So we just tell people not to use it, right? So those are the things that you need to understand. I had never thought about it. I probably should have. But there are going to be certain things acting on, if you're ever in a coalition operation we're going to be operating under the same law. So this goes back to the sources, but the way that we interpret it and implement it are going to be very, very different. Another place where this comes up is a lot of our allies are parties to certain protocols of the Geneva Convention where they just view who's involved in non-international armed conflicts differently, right? So in the United States, we think that a non-state actor group, we treat them like they were an army just without a government. And that means that the people who belong to those groups, we consider them combatants, and they are targetable all the time, right? If in the United States, if you're in supply or if you're an infantry officer, if you're a member of we consider that if you're a member of the group that we're fighting, you are targetable, right? But our allies and partners who are parties to these conflicts, they believe that you only have combatants in international armed conflict. You never have combatants in non-international armed conflict, right? What you have are organized armed groups, and everyone who belongs to those organized armed groups are civilians. And those civilians are only targetable for such time that they're engaged in hostilities, directly participating in hostilities. There is a certain small group of that. There's a subset of the group that are in continuous combat functions of that organized armed group that they're always targetable because they're it's too hard to figure out when they're directly participating, so it's always targeting. Now you can see why that's going to be an issue, right? So if we're under the United States standards, thinking that we can target someone in a drone strike if they're a financier. And we're working with the Brits, and they're saying, well, no, we have to do whether they're directly participating in hostilities, even though they're a member of this group. That's the delta, right? And if you don't understand the obligations that the people who are parties to the additional protocols of the Geneva Convention have, and how it differs from the United States view, you're going to have a lot of frustrating conversations. And so that's one place where it came up. Another place where it came up is you always have to account for sovereignty of the country where you're fighting. And we do that in several ways. Like in Afghanistan, we were fighting the Taliban for a while, and then we installed a government that gave us consent. Consent solves everything, right? So we can consent, and the operation takes place there. Iraq the same way. I think this really comes up when you look at the fights with ISIS that span Iraq and Syria. And this came up when I was advising a strike group where we had British officers on board. We had exchange officers who were British pilots. And at the time, the UK and us, we agreed like how we could operate in Iraq, right? We had consent of the Iraqi government to strike ISIS in Iraq. But we were also like striking targets in Syria. Did we have the consent of the Assad regime to like fly into Syria to violate their airspace? And no, we didn't. So what was the United States theory? Like what was the international legal theory that we could go into Syria in this instance? And we subscribed to this theory that's called unable or unwilling. So it's this theory under international law that you don't need the consent of a country to counter a threat if the regime or the government that won't give you consent is unable or unwilling to address the threat. That is something that we relied upon a lot, and it's not something that's always been, it's not pretty clear. We say it's customary international law because there's no treaty that says it, but a lot of people disagree with this, that it's customary international law. And at the time, we had British officers, and the UK didn't subscribe to that theory. So we would do these sort of pre-flight planning, and it was very important for us to say that the British people who were flying missions off our ships could not go into Syria because their government didn't believe that our rationale for going into Syria was justified or was a theory that they wanted to stake. And so all the British pilots had to fly into Iraq. And that has changed. And what changed was there were attacks in London, right, on the bridge just outside Westminster Palace. And then the Parliament came out and said, there's unable or willing international legal theory we're going to buy into. So that came up based on things that happened at home. All right. And then present. The present is where we are today. I think the thing that I will hear is that the international armed conflict would have been the easy question, I thought. But I'm always proven wrong. And now that we're sort of in this strategic competition mindset, international armed conflict are two countries fighting each other, and that's clear when like their armies are open. But what we're finding now is that that's not how states operate anymore, right? So you have the Houthis, you have the Iranian proxies in the Middle East, and there are a lot of questions. But like if we are engaged in fighting the Houthis in the South Red Sea, at what point are we actually fighting Iran, right? Because the Houthis, under the U.S. view, not a government, right? So us fighting with the Houthis is more like the past than the present. But if you start looking at all of the armed groups in the area, the Hezbollahs, all of them have being very precise in my language, all of them have various ties to the Iraqi regime. And so their relationship's going to look different. But you need to come up with a standard to say, when are we going to make Iran responsible for the actions of these proxies? Is it just doctrinal guidance? Is it command guidance? Is it financial guidance? Like what does that there? That's sort of like armed groups. But when I was in Africa, there was also this question of like, if a country like Russia has an oligarch like this guy named Prigozhin who is running these private military like companies in West Africa, like when can we attribute? And they were committing crimes, right? They were committing. What would happen is that like certain African countries would hire them for their counterterrorism, and then they would comport themselves not in compliance with the law of war or the law of armed conflict. At one point, are those atrocities attributable to Russia, right? And I think it's a very complicated question, and it's one that requires legal advice, it's one that requires intelligence input, and it's one that requires a lot of discussion. So I think that's why I think things like this conference are very important. And then legal statecraft, I hate the term lawfare. So of the two words that I ban in my office, this is one of them, and not because I like to ban words. I think lawfare to me kind of seeds ground. So the notion of lawfare, and you often hear it in the context of China, is that China is manipulating the law to its ends. And I think if you think that's the case, or you think that's available, like I think calling it lawfare, right, is agreeing with them, right? So I think if you're calling it lawfare, I think there is an implication that the law is more than just a tool that you use. It has legitimacy on its own, and it's not something that you use for your ends. It's something that you use for the common good, right? And I think equating it to some mechanism of warfare doesn't make it's not a good narrative for you. So I call it legal statecraft. But and then for the future, and then how long? When did I stop? Oh, okay. All right, and yeah. So we'll talk about what I do now. Which is this is interesting, and I'm sure lots of people are interested in this. Is that AI? A lot of conversations about AI. People want to talk about it, but I also think I guess my takeaway from my recent experience with AI is that a lot of people think things are a big deal that aren't. And a lot of people think are not tracking things that are a big deal. So I think sometimes we get focused on the shiny thing and we're concerned about the wrong things. Because people are spooked out about not having a human in the loop. You hear all these terms. But I think a lot of times, and I see this a lot. So what's happening now is that we have a federated or a joint targeting cycle. And a targeting cycle is this doctrinal thing that is established at AFRICOM or at COCOMs, where you have a process for identifying targets, and then you have a process for validating the target, saying this is a valid military objective, and then once those get added to a list, you engage a target, right? Or you give someone authorization to engage a target. So, identify, validate, engage. And in each one of those steps, there are procedures in place to make sure that you're considering the right things. And I don't see, and you guys, you're willing to argue with me on this. It's like if I'm in Stuttgart at AFRICOM and I'm in the identify, validation, or engagement process, and we get an input that's SIGINT, right, that we didn't observe, and that input has been vetted and validated by experts to say that we can trust this, right? I have never seen a commander in a targeting decision saying, when was the last time you calibrated the software that determined this signal's intelligence, right? The person who's making the decision, the commander who's making the decision, trusts that there are processes in the background that when it gets to his or her desk, right, it's valid, right? So if the commander is getting SIGINT and he's not asking about the software that produced that SIGINT, why does it matter if as long as whatever produced it is valid, why does it matter if it was that program was ones and zeros that people put in, or that program was ones and zeros that was established through machine learning? I don't see a difference, right? But because one is AI and one isn't, people think it's different, right? If it's invalid if it doesn't meet the validation standards, it doesn't meet the validation standards. You shouldn't use it in targeting. But if it meets the standards, if it is accurate this amount many times, I don't see why whatever produced that accurate result matters. So what I'm saying, it doesn't get accounted for in the targeting process. It gets accounted for in the procurement and fielding process. But I think that's the distinction I'm getting at when I'm trying to say, don't talk about AI. Talk to me about the system, right? Because right now we're talking about sort of remotely piloted surface vessels. And they'll say AI surface vessels, but I think if you think about it, it's you have a vessel that is remotely piloted, meaning there are machines on board that respond to inputs that come from offboard. I think you have to establish that's your platform, right? Then you look at what are the inputs? Is there a person deciding what the inputs are, watching it through whatever mechanisms it can communicate with the ship? Is there a person deciding that? Is it a person input? Or is there some algorithm deciding the best way to go, and is that the input? And then let's talk about the person inputs and the algorithmic inputs. That's another issue, right? So if you see, this is what I mean, it lowers the cost to entry in very important conversations. Doing that requires you to understand the way that the system works and to understand the steps, but it's such a better conversation. Because if you say, I have a problem with AI, which part of AI? The SIGINT, do you have a problem with using SIGINT in targeting? Do you have a problem with over-the-horizon targeting? Or do you have a problem with, does it give you the heebie-jeebies that a human's not involved? And not that the heebie-jeebies is an improper consideration, but I need you to tell me why, right? And I think this is what I talk about down there. There is always a tension in the law of armed conflict between people who want to regulate things and people who want to ban things. And I am firmly in the regulation camp. I am not in the ban camp because here's my experience. So when I was working down in Virginia Beach, we were involved in a hostage rescue. She was a woman, I think Jessica's her name, Buchanan. She had been taken hostage. She worked for the Danish demining company, and she was taken hostage by pirates on land, which was another legal discussion because there was an issue whether if they're on land, they're still pirates. But because under international law, piracy has to take place in international waters. But we have always done legal reviews. It's for every bullet, for every weapon we use, there needs to be a legal review. And usually this review happens when we move from research, development, testing, and evaluation to procurement. I was at a development command, so the funding got very questionable. But the funding wasn't questionable, the pots of money they were coming from was questionable. But there has been an issue since Vietnam that the typical round that the 5.56 round, is meant for sort of long-range combat, right? It has a charge and its penetration capability is meant from long distances. And as we move closer in sort of the war on terror, it still works and it still has a legal review, but there's some issues with it. Like it slices, right? One thing is it penetrates bulkheads, and so it can go through what you're not shooting. Another thing is if you're at a person, the way that it slices through your body, and it like vaporizes your tissue, and so you're going to die, but you're not going to die right away. So like if someone is running at you at close range and you shoot them with that type of round, that person is still going to be able to fight for a bit. But in a hostage rescue situation, you can see why that's bad, right? Because if we're trying to not kill somebody and they're in a room, you don't want a round that's going to like slice through a person or slice through a bulkhead. You want a round that's going to stop. So there are these rounds that are called reduced ricochet limited penetration rounds. There's a reduced charge, and the front is chopped off so that when it hits tissue or a bulkhead, it yaws. So it's going to tumble through the body. So instead of like slicing through the skin and vaporizing the tissue, it tumbles, and that means it stops, right? However, we were testing those and evaluating those for hostage rescue situations because there was a hostage rescue mission at parts of this command, but it hadn't had a legal review. So I was like sitting there advising on this hostage rescue operation, like, hey, we need a legal review on these reduced ricochet limited penetration rounds. These rounds, by the way, are often used by law enforcement. So I mean, it's not like they're a questionable round, but it just hadn't had a legal review. It's like, okay, like when do we need it? It's like, well, the guys are down climbing into the boats to go rescue her now, and they're loaded in their weapon. So I was like, oh, so this is an emergency legal review, is what you're telling me. But we got it. We got done, and she was rescued very, very successfully. But it's just this is why I don't like. So why is it I had to? I wouldn't say it was an easy legal review, but why, it was easy because it was in a context that wasn't international armed conflict. It would have been a harder context if we were fighting in another nation. Because why would it be a hard context? Why would it be if we were fighting in another nation? Because there's this thing called there's this Hague Convention in the late 1800s, and the Hague Convention in the late 1800s has a prohibition on expanding ammunition. And at the time, expanding ammunition was meant to design maximize suffering, right? But that's not what they wrote it, right? Is expanding ammunition. So when a reduced ricochet limited penetration round doesn't have the tip on it, and it's not meant to suffer, it's actually designed to advance to the law of war principles of not targeting the civilian or not penetrating the bulkhead. But I still had to account for this ban because in the 1800s, the people who came up with this ban thought they could define something in such a way that it's going to account for every technological advance that's going to come since then. And you see this in cluster munitions. The people who are for the ban on cluster munitions, they have a good point. But I also think what happens if you push for a ban is that we're not going to sign up for it. So the people who are going to use cluster munitions don't subscribe to your ban, and so what good is it, right? I mean, it helps for fundraising. But if you get the people, but I think the United States position, as I understand it, is listen, we're not going to use cluster munitions in the areas that you're saying. So the issue with cluster munitions, right? It's a munition that opens up and there's other submunitions in it. The issue is a lot of times that they don't explode. They have a high error rate. And so what happens with them and why people want the ban is that they will use them in urban areas. These bomblets won't explode, and then kids will be playing years after the conflict is over, and they will blow. It's the same thing with mines, right? So they want to, because of that, they want to ban it everywhere. I think the United States position is we're not going to sign up for this ban because we understand the circumstances you're worried about. We don't use them in that situation. But what we do think is if we ever need to follow an airfield, cluster munitions are the best way to do it in the fastest way possible. So what we're not going to say is because of your concerns in a civilian part of town or in a high populated area that we're going to not use it to follow an airfield. So why don't we talk about regulation? And in a regulation, you tell us not to use it there, right? But you see this in lots of places, right? The Ottawa Convention for proximity mines. People with very good intentions want to ban things, but I don't think they're seeing the whole picture. And you're seeing this right now with AI, right? You're seeing people who want to ban AI. And I think this just obviously I'm triggered, but I just don't think bans, I think bans look for try to pursue a good goal, but I think they are not effective because one, you can never define something now that we're if we tried to ban AI, think about this is the Ottawa Convention on steroids, right? If we tried to ban AI now, which I think AI is useless, it's not defined, do you think we can account for what AI or any type of machine learning is going to look 10, 20, 30 years from now? And I don't want the lieutenants in my job in the future to have to deal with this inartful definition that we drafted. So I think regulation is the way to go. And also, the United States, we're not going to sign up for a ban, flat out, right? So you can go to these workshops and say, you have these people who are talking about we need to ban AI, and well, that's fine, but and good luck. Or, we wish you well on your endeavor, but we're not going to help. So, I mean, that's that's a political reason. So, all right, that's what I have. Or what questions do you have? I'm looking forward to your questions. So. Hi, good morning.
Hi, sir. I'm Colin Age. I'm the Army rep at NGA. Very interesting question you asked us about